Hey, Juanita.
Hi,
How are
Mark.
you
How are
doing?
you?
Fantastic. Mark Westcott and Juanita Maiden with you today, estate and succession mastery. And we did such a good job last week on our 12 will killers, Juanita. We only got halfway through it. So
That's right. We're
today
back
we
for more.
today we go back for more and see if we can finish them off. So um, we had some response from last week. Some of the people who were watching the show last week liked our conversations around the first six. So the
Okay.
seventh one is. Now, these are will killers. So these are the things that, many people have got wills and think everything's taken care of. And so what I did, I created a list of 12 will killers. And basically what it is to say, well, no matter what you've got in place at the moment, there's always a chance that something will come up and give you a fright, bite you.
What can go
And
wrong? Yeah.
these are the things that can go wrong. So the seventh one, and the one we'll kick off on today, is blended families and stepchildren. So far away. Juanita, what's your thoughts on this?
Great topic. Great topic, because this is becoming so much more common in these days. Blended families, second families. I myself am a wicked stepmother, although
Oh,
hopefully not wicked. So look, it's really common. Yeah, and so the point here, I think specifically, is to get the right advice about what the law says about what entitlements second families and stepchildren, etc., have. But I think more importantly, making sure that your intentions are reflected in the documents you have. It's often that you might put a will in place, and then life changes, things happen, and does what you have in place actually reflect what you want? Of course, with stepchildren and blended families, there's that added point to consider, I guess, that there's two sets of parents and step parents as such, and so um, it's worthwhile talking through and thinking about where those children will receive their inheritance and how that will flow through. So it's just a thinking process, making sure you're aware of what everyone's rights are, about what you want, and that your documents reflect what you want.
sure. So let me throw up a scenario, Anita. So let's say mum and dad, and let's just say they have three children. They've known each other since school.
Do I need
They
to
split
take
up.
notes, Mark? Do I need to
No,
take
no, no,
notes?
no. It won't be that long. But let's just say they've known each other since school days. They get married. They have three children. They build an estate, and let's just say $5 million. So they build up an estate over a number of years, and let's just say there's not a divorce. Let's just say one of the parents dies, and over a period of time, the remaining person remarries and remarries someone with five kids. Okay. Now, there's no doubt that those two people created wealth together. It was always their intention, as they were going through life, that their wealth was to be for the three children, which were their children. Now, so that person has remarried someone else who's got a swag of children themselves. Looking at it just as an outsider, you'd say, well, that's not fair if you then divide the estate between eight children if the other person's turned up with nothing. We refer to it as sibling seepage. In other words, all the stepchildren come in and all the wealth dissipates where it probably wasn't intended in the first place. But then the other side of the argument is, over a period of time, maybe there is some entitlement, and I won't use the word entitlement, but there's some fairness would be to distribute some of that if they've been together as a family unit for a period of time. So what's your thoughts, or what's your advice for people who are in situations like that?
Yeah, well, two things jump to mind with that scenario that you just laid out. In that case where we have a second marriage, it's quite common that person might choose to leave their estate to their second spouse and expect it to be flown down through the next generation. So that could cause problems for the children of the first marriage, who are concerned that they might be left out by their step-parent, obviously. What a lot of people don't know is that a stepchild is able to contest a will of a step-parent. So that surprises a few people.
Be included.
So that doesn't necessarily mean they'll be successful, I should add, because just because you're eligible to contest someone's will doesn't mean that you will get anything, and that's a whole nother topic, Mark, we can do one day. But yeah, I think what is important is things such as you raised about the length of the relationship with the second spouse and with all of the children, any contributions that are made between the respective parties, not just financially but emotionally as well. So it sort of reverts back to some of the things we've spoken about often about communication and making sure that your intent is reflected in those documents that you've got.
Sure. No, very, very good answer. But it's a tricky one. I mean, in the early days, I used to call it the Anna Nicole syndrome, where that old guy that had all the boys lined up ready to take over the billion-dollar business, and he ended up marrying Playboy centerfold, and all of a sudden the boys are lining up saying, "Dad, what's going on here?" Suddenly he'd given it. He wanted to give his estate to his new wife. So it's a thing. I think you need to have a conversation early with your children and so on, obviously, and get some things locked away so that there's fairness and the original intention of the parents is honoured. And I guess that's the point, isn't it?
Yeah, absolutely. Yeah, and just another thought. As you were speaking, then obviously sometimes in a second marriage or a blended family, you might have a range of different ages of children. And obviously younger children might have more immediate needs for their education and maintenance, etc., than adult children. So that's, one of those things that you need to think through also as part of your estate planning.
Yeah, how do you raise that subject though when you, excuse me, so you're going into a new relationship and, that person has a lot of wealth or you have a lot of wealth and you've got children? Gee, it's a bit like a prenuptial conversation in some ways, isn't it?
It is, and it's not an easy conversation for a lot of people, and I think that's where getting the experts involved to help that conversation, like yourself, Mark, is very useful, because it is a tough conversation. There's no doubt about it, because everyone goes into a relationship with the best of intentions and the best of plans, and just like in businesses, I guess you need to discuss those sort of things right up front, which make it a lot easier to deal with any issues down the track.
Yeah, and as I've said many times before too, these sorts of conversations, I sound like a broken record here, but these sort of conversations are best held by someone outside the family. Very hard to hold them inside the family and have a good outcome. It's very much easier to have someone else come in and they can be the bad guy about raising the tough topics.
Yeah, that's right. I agree.
Okay, number 8. Do you want to talk about that one?
Well, I think it's a very.
We'll just better give the heading first.
Oh well, we will. Okay, number 8. We're up to number 8. Delinquent documents and out-of-date documents. So often people will put their documents in place and then put their copies or their originals in the top drawer or in the storage shed, gathering dust, never to be seen again. This is what we would call a delinquent document. But probably more seriously is that a lot of events in your life can affect your documents. So when we talk about appropriate times to revise your wills, when you get married, divorce, buy a business, sell a property, have children, etc., all these significant events are triggers for you to review that you have the right things in place. So, for example, a lot of people are unaware that if you get married and have a previous will in existence, unless it's specifically drafted to contemplate that scenario, your will be revoked. So a lot of people will get married and then carry on for a period of time, totally unaware that they actually have no will in place. So perfect example of a delinquent document. So not only are we worried about having the right plan in place in the document, we're also worried about that there's actually a document in place in that scenario.
Absolutely. One of the famous ones was the case of Theresa Rain, wasn't it? I'm not sure if you're aware of this.
Kevin Rudd's wife, isn't it?
Mrs. Rudd. That's right. Theresa Rain. Yep. Yeah, she had a buy-sell agreement, and I mean, if you search really hard, on Google. You can find it in the bowels of Google somewhere. I think they hit this case pretty well. But basically, she had an agreement with her business partner, and on the event that one of them died, the other person could buy it out at a predetermined figure. But the trouble was that when they made the agreement, it was worth bugger all, the business, and of course then it grew and grew and grew and was worth 10 times as much, and the other partner died, and Theresa Rain basically said to that lady's estate, well, here's a check for X dollars, and they're saying no, it's worth 10 times that, but because they'd never reviewed the document and updated the figure, they settled for the original X dollars. So you need to be careful in buy-sell agreements or any other documents where there's valuations that you make sure that method of valuation or the numbers are actually kept up to date.
Exactly right. That's right. So in that particular case, it was the content of the document that was inappropriate and the valuation process that was set out. So, certainly great example of a document that can become delinquent, and also remembering the law changes. The law is never, stagnant. It changes slowly often, but it does change. And so a document or the content of a document that was drafted many years ago might become not the best advice now, or not the way we would recommend that document be drafted or structured now, because the law has changed over a period of time.
Sure, and I mean the reality.
I don't want to scare people. I don't want to scare people. That's an extreme example, but not that something wouldn't be relevant, but it can be drafted in a better way as the law evolves. I suppose is a good way to put it.
Yeah, you're being very diplomatic there. Thank you. I'm surprised that they actually put numbers in a buy-sell agreement. Most buy-sell agreements have a formula.
Absolutely.
Times earning or evaluation of some form. So but it just raises the point, and I'm at the risk of plugging your business again here, Juanita. That once again is something that you guys would find in a due diligence report, where you're actually going through all the documents, looking at that. So that's why it's such an important part of our process is you going through and doing that due diligence for the clients.
Trusts are another great example of that. So, trust law has changed significantly over the last 20 years, particularly to do with taxation. And so a lot of old trust deeds that have gathered dust from 20, 30 years ago are not what we would recommend these days to suit the business owner that wants to put a trust in place to utilise that.
Absolutely. Okay, so moving on, number 9 out of the 12 will killers is promises not being funded. So if I can just start on this one, if I may. The reason I put that down there is many times people may have in wills they've done in times gone past put down that Sally's going to get the house and Fred's going to get $1 million and David's going to get the business and Juliet's going to get the other business down the road or something, and they've been promised effectively a lifestyle or an asset level or some sort of future promise, but in reality, by the time that person dies, there's debt levels or properties have been sold, situations have changed, and so on. So, do you see that very often, where people actually in their wills sort of promise certain things to certain people, and then by the time they've passed away, those assets have actually disappeared?
I've seen an example very recently. So there's a couple of issues there where someone, as you said, might leave $10,000 to Bob and the rest to Jane. Well, if there's not enough, if there's not $10,000, just an example, figures, what happens then? Jane misses out. Or on the flip side, you might leave a horse to Bob and the rest to Jill. But what happens if the horse dies? So, Bob doesn't get anything now because the horse is gone. So that's right. Also relevant in this particular topic is, as you mentioned, what debt carries with assets. So you might leave a property, and unless you've specifically addressed how you wish the debt on that property to be addressed, in your will or in your estate plan, that debt, for example, that mortgage will carry with the property, and how will that be serviced, which, it's not necessarily a bad thing, but it's something that needs to be thought through. So, it's all well and good to give a specific monetary gift or a specific gift of an object, which carries, lots of risks with it. But I guess beware if you don't have those funds at a later date or that object.
And obviously that would come up a number of times where people have thought about using life insurance as a funding method for their estate. So they figure, well, I've got $5 million worth of insurance, and that will allow, my wife to keep the house, and it will allow, an income stream of, $150,000 a year for the rest of her life. And so they actually, people sometimes put that in their wills, don't they, to that level. And as you say, the insurance, somebody forgets to pay the premium on the life insurance and the whole intention. And so if other assets are being left to other people, well, all of a sudden, the spouse is going to get nothing, and it just goes it just turns into a squabble.
Yeah, and a little off on a tangent, but for people that sometimes don't have a will and think, well, that'll all just go to my spouse anyway. What can happen if you have children is that the pool needs to be split up per the law, and you can all of a sudden have your spouse having to share ownership of the house with the children, and that's not a really great situation to be in practically for the spouse. So again, a promise not fulfilled, I guess.
No, it raises a whole lot of issues, and once again, check your documentation and get this sort of stuff reviewed.
And there's a real common theme with all of this, isn't there, Mark? Just making sure everything's updated and reviewed, and that the right questions are in place, and the right communication between everyone has been undertaken. Look,
absolutely, Juanita. I mean, when you look at all these 12 will killers that we've got here, starting from, let's just go through the first 6 just quickly as a recap from last week. First one was inappropriate executors. So, who do you have and how many? Second one was asset protection. Will your estate be protected from foul marriage, bankruptcy, and death out of order from other people and so on? Are there any black sheep in the family? What have you done in regard to your documentation to make sure that they're taken care of? And that can be people with special needs and so on as well, people with alcohol addictions, drug addictions, and so on. The fourth one was, will the right money go to the right people at the right time? 5 was fair, not equal estate distribution. So if you've got one child that's been working on the property, the farm for years and years and years, and the others haven't contributed at all, how do you create fairness? And the 6th one was just a lack of family awareness and consensus to make sure that you don't have those squabbles and fights after someone passes away. So, and all of these are solved if you sit down once a year or once every couple of years, at worst, to just go through those issues with someone who asks the right questions. And you're absolutely right. It's the power of the questions that are asked that make sure that these things aren't.
Absolutely. Yeah. As we've said many a time, the end result or the end documents may look relatively simple, but it's the questions that get asked and the process in that goes into putting that in place.
Yes, the unknowns. So, okay, number 10. Not all assets pass through the will. You have family trusts, superannuation, life insurance, and so on can be, can be owned by other people or can have other beneficiaries. So, you would see a bit of this, wouldn't you, in your work in estate?
I wish I had $1 for every person I've seen that did not realise that superannuation doesn't pass directly through your will. It doesn't form an asset of your estate necessarily, unless you direct it there. Most people have no idea as to that. So if you didn't know that, you're not alone. So examples here: superannuation. With superannuation, in general terms, you need to provide a separate nomination as to who you wish your super to go to. That may be the estate, so it may pass through your estate, but not necessarily. And the kicker is if you don't have a nomination, usually that means the superannuation trustee, if you've got a retail fund, has a discretion of who it goes to. And I am yet to meet anyone that's quite comfortable giving their trustee the discretion about who their hard-earned funds go to. So that's a very, very common conversation with people not realising how superannuation flows after death. You mentioned life insurance. Again, life insurance can nominate specifically an individual as a beneficiary or the legal personal representative. So when an individual is nominated directly, that will flow directly through to that person, as opposed to, again, going through your will and your estate. Trusts we've spoken about previously, in that the assets that are owned by a trust remain owned by that trust if you die. If I have a trust, I die, but those assets stay within that trust. What does pass is the control of the trust. So again, one of those
that can be tricky, can't it?
It can be tricky. It can be tricky, and it all comes down to what's in your trust deed. Those delinquent documents we were talking about before, you need to dust them off and check. And
sure.
Another really common one that people aren't necessarily aware of, along with the super, I find, are joint assets. So if you have a bank account jointly, obviously extremely common of the husband and wife having a bank account. When one person dies, the other automatically becomes the owner of that joint asset, and it does not pass through the will. That also applies to property in some cases. So without getting too technical, you can own property in different ways as joint tenants or tenants in common. If you own a property with someone as joint tenants, and to be fair, that's the usual scenario we see with husband and wives, it'll pass to the other immediately on death. But there may be reasons why we don't want that, because we might want to make use of testamentary trusts in your wills, for example. So that you can see there's quite a lot of examples where an asset may not necessarily pass through your will. So, how important is that to know, and to know where it is going and be very clear? And that can be useful too. It can be, it's not a bad thing. It can be used strategically to benefit the scenario or the plan that you want to put in place.
Yeah, absolutely. And when all else fails, seek professional advice. And certainly one of the issues you talked about there, real estate being owned in joint tenancy, I mean, that certainly doesn't go through the will, does it? So if your house with your spouse is owned, that's just going to go straight to that person. The other thing is, as a warning, I guess, is that the beneficiaries of your superannuation fund, the beneficiaries of life insurance or the ownership of life insurance, wow, that's something you need to keep check of, because like you, I'd like $1 for every time someone's been divorced, and a year or two later they find out that their ex-spouse is still the beneficiary of their insurance.
Yeah, that's right. Even if they've changed their will, that's right. And also on that topic with your life insurance and super, as you know, Mark, there are a really significant tax, what should we say, results depending on which way you leave those assets, and you need specific advice on that. You need professional advice, and that's where it's good to get your fin planner or your accountant involved in that as well. And perhaps just one final point on that: when we say not all assets pass through the will, that could be an advantage if you are particularly concerned perhaps about someone contesting your will. It may be that you don't want them to pass through your will. That's right. So in that way, that's an example of where it could be a good strategy for an asset not to pass through your will. But you don't just take that piece of advice on that one sentence, because it really has to be part of a discussion about the whole estate and the whole plan. Absolutely.
And the more we talk about this, anybody watching this would be going, wow, there's so many things to think about. And I guess that's what we bring to the table is that you do need to have the right questions asked, and you do need to know what to look for, because if you don't know where to look, you're going to get yourself in big trouble. Number 11 is, what about business succession? So you might have set up your will, but I mean, in the will, you might, if you own shares in a company you're in partnership with someone with, so to speak, or own half the shares in a business, all of a sudden the spouse owns the shares in the business. And was that really the intention, that your spouse was going to end up going to be in business with your ex-partner? So there's a whole range of things in regard to issues around succession planning, which really probably most times are best handled outside the will too. Sorry, in conjunction with, but primarily outside the will.
Yeah, and you need to think about how you would want your business to succeed, not only, well, firstly after your death, but not only that, so also during your lifetime, because it may be a situation where you get ill or you lose capacity. What's going to happen to your business then? So that's something that we need to address. Also, you know, it doesn't have to be negative. You might want to retire and enjoy the fruits of your labor, and how will that succession flow through while you're still alive, and you can get to benefit from that. So these are the discussions that need to be had. And as you said, we need to identify in what entity the business is run. So is it a company? And so therefore, do we need to deal with the shares? Is it a trust? And therefore, we need to deal with the control of the trust. So yeah, really specific questions as to how the business is structured and what your intentions are and what you would want to happen if you were alive and after you pass away. And you mentioned buy-sell agreements before when you were talking about Theresa Rain, and obviously these are you know, documents that are relevant to your business. You might have shareholder agreements, you might have partnership agreements, you might have buy-sell agreements, and you know, these are all obviously a high priority to put in place and to see how they deal with these situations and make sure that they align with your will, or complement it as such.
I'm confused just going through this list.
So we could talk about this all day again.
Absolutely.
Love it.
I'm glad we didn't try and cover all 12 issues in one go. Number 12, the final one is, what if mum and dad, mum or dad remarry? Well, so there's a will in place, mum and dad remarry. You know, how do we go there?
Yeah, well, we spoke a little bit about this before, didn't we, when we spoke about blended families and stepchildren. So, you know, a lot of those, I guess, topics we touched on there are relevant here. A lot of people may have heard of a term called mutual wills, and you know, this is, I'll just touch on it briefly. It's not particularly common, but you have the ability, if you remarry, to if you are in a couple, to make what's called mutual wills, which involves a contract not to change your will when one dies. So often useful if you have blended families, I suppose, and you want to make sure that your children, your biological children, are looked after. But look, that's not just a basic will. It's quite a complicated will, and it's a contract involved. So it's different to what we call mirror wills, which are just wills in reverse, he said, she said. So you look, that's out there. It's possible. But I guess the key here, I think, is to answer the question, what if mum and dad remarry? What do we want to happen? And then make sure that the documents that we have in place reflect those wishes, and make sure that that does happen, and that we don't have anything go sideways.
Yeah. There's some interesting questions that have been raised in the 12 will killers, and probably if I tried a bit harder, I could get that up to 20 or 21. But
we'd be here for weeks discussing.
Look, absolutely. But I mean, the truth is that they are all very valid issues, and the point about all this is that, you know, a lot of people get a will done. They get very excited about that, very proud of the fact. They stick it in their top drawer, and 15 years later they pull it out and there's dust all over it, but they still think it's relevant. And I guess what we're trying to do from a constructive point of view is just give an awareness of the fact that, you know, no matter how well you think you're being looked after, and a lot of people also suffer from the fact that because they've got expensive lawyers and accountants, they kind of think that all this stuff is taken care of and they don't have to worry about it. This is not something you just delegate and forget about. You really need to check in each 12 months, each couple of years, and sort of go through a list, go through great questions, and get all these stuff. All these sorts of things.
That's right. No, and we know we're not trying to scare people, but you know, it is just a fact that from the bad things that happen, or the unfortunate things that happen that we see in our profession, we can you know, use those experiences to make sure that they don't happen again, or don't happen to our clients. So hopefully, you know, it answers the question that a lot of people say, why do I need a will? Or why can't I just go do a newsagent will kit? You know, this is why, because there's all these potential issues that can happen.
Yeah, and you're absolutely right. Don't listen to us and get scared about a will being too complicated. hopefully our role is to make it simple for you and make sure
these things don't happen.
Don't happen. Okay, thanks, Juanita. Another great session today, and look forward to catching up with everyone again next week. Thanks, Juanita.
Great. Thanks, Mark. Thanks, everyone.